Good evening, everyone. My name is Liliana. I am a volunteer member of Latina Women Against Violence, which is a nonprofit community and volunteering group run by and for Latin American women living in Ireland. We fight domestic violence and other forms of violence against women. Our mission is to inform and raise awareness about domestic violence, to provide safe interaction and follow-up to victims and survivors of domestic violence, to train group members and empower other stakeholders in relation to domestic violence, self-care, and mutual care, and to provide growth tools to empower Latin American women in Ireland to achieve personal and social change. This is the fourth and last workshop of the series Break the Cycle, or Rompe el Ciclo, organized by Latina women. Our workshops are free, and this is thanks to the support of our sponsors. One of them is the Venezuelan Community in Ireland, which is a charity organization registered in Ireland that supports the integration of Latin Americans and the promotion of the Venezuelan culture, and they provide us with the Zoom platform. And our second sponsor tonight is the Immigrant Council of Ireland, which is a national, independent, non-governmental organization that promotes the rights of migrants, improving and protecting their rights since their organization establishment in 2001. Today's workshop is titled, or is called, Information Session, Immigration Support for Women in Situations of Gender-Based Violence, and is facilitated by Ioanna Negrello, who is a case officer from the Immigrant Council of Ireland. This information, the information shared in this workshop is provided for informational purposes only and is not to be construed as legal advice. Ioanna joined the Immigrant Council of Ireland Law Center as a legal information officer in February 2022, and she holds a law degree and an ELLM in International Human Rights Law from the Irish Centre for Human Rights at University of Galway. She's qualified as a lawyer in France in 2020, and prior to working at the Immigrant Council, she gained experience in a number of NGOs, including an organization working with victims of human trafficking and Migrants' Rights Center. The first part of today's workshop will be recorded and uploaded in our YouTube channel as part of the Break the Cycle series. The second part of today's session won't be recorded, so we aim to have questions from participants and to feel that their privacy will be respected, so we won't record the second part. If you have any questions or any comments, you can raise your hand, and towards the end of the presentation, Ioanna will be more than happy to answer your questions. And if you struggle a little bit in writing your questions in English, we're very happy to support you. You can write them in Spanish and we'll translate them at the end. Ioanna, we are very, very happy and grateful to have you here. And please, the floor is yours. Thank you.
Thank you very much, Liliana. Good evening, everyone. Thank you for having invited me tonight. And thank you for the introduction as well. I'm just going to start sharing my screen so I can share my slides with you. Can everyone see the slides?
Yeah.
Perfect. So I'm just going to start just there. Perfect. So as Liliana said, so my name is Ioanna. I work at the Immigrant Council as a legal caseworker. And today's presentation is going to be focusing on immigration law and gender-based violence. So before I get into the crux of the presentation, I just wanted to talk about our organization, the Immigrant Council. So some of you may be familiar with the Immigrant Council already, but if you're not, the Immigrant Council is a non-governmental organization which was founded in 2001 by Sister Stanislas Kennedy. And what we do is that we work with migrants and we support the rights of migrants in various capacities. So we foster public debate on immigration and integration, for instance. We also tackle racism. We work on immigration reform and advocacy as part of our law center. And we also provide practical information and advice on immigration-related issues on our helpline. So as part of the Law Centre, we have an information and support service, which is the helpline that I mentioned. It is open to the public, and we also have a dedicated helpline for the citizens information services. So these would be your local citizens information centers, for instance. So if you go to them and you have a question about immigration or that they're not able to answer, they will call us directly. And the helpline that we have with them is open every day from 10 a.m. to 1 p.m. in the morning, and from 2 p.m., if I'm not mistaken, until 5 p.m. In the evening. And then we have this other helpline that is open to the public, which is open from 10 a.m. in the morning to 1 p.m. on Monday, Tuesday, Thursday, and Friday. So it is closed on Wednesday. And we also have an evening helpline on Tuesday from 7 p.m. to 9 p.m. You have the phone number there if you want to take it down, 01674 0200. And I would be sharing all the phone numbers and email addresses that you can contact us on at the end of the slides as well. And I'm more than happy to share my slides with everyone as well at the end. So what you can expect when you ring the helpline is to be connected to one of the helpline staff that will be able to answer any questions that you may have that relate to immigration law. So it can be about citizenship, family reunification, making an application for a visa, or regularization if you are undocumented. In specific instances and where we highlight vulnerabilities, a caller can be referred to a caseworker or a solicitor that works at the Law Centre for further support. And it goes without saying as well that the service is completely free of charge, and it is also strictly confidential. Again, so at the Law Centre, we have that helpline, but we also have the Law Centre where solicitors and caseworkers work and provide free legal service to service users and or clients. We do have very limited capacity because we're a small team. And again, we do provide services that are free of charge and confidential. And we try to focus on addressing specific vulnerabilities or unmet legal needs. So this would be, for instance, working with victims of human trafficking, working with children who might need support in terms of applying for family reunification with family members, etc. We do receive referrals from the information helpline, but we also receive a number of referrals from other organizations. It can be TUSLA, it can be the HAC, and it can be other NGOs or domestic violence services. An area that we really try to focus on is gender-based violence. So we support victims of human trafficking and we support victims of domestic violence. For victims of human trafficking, there's a very specific route that has to be followed. So if you do come across someone who has experienced human trafficking, it's very important that they receive legal advice. So it has to be provided by a solicitor. I'm not currently working as a solicitor at the Immigrant Council of Ireland. So for instance, I am not qualified to provide legal advice to a client. So if a victim of human trafficking comes or makes contact with us, one of my colleagues at the Immigrant Council who work as a solicitor will be in a position to provide them with legal advice. When it comes to victims of domestic violence, it is not necessarily the case that they will be required to be represented by a solicitor. So very often a legal caseworker, such as myself, can support them. I have my email address there if you want to, sorry, I'll just go back. If you want to take it down, so support@immigrantcouncil.ie. This is my personal email address. So if you want to refer someone to us who has experienced gender-based violence. So again, it can be domestic abuse, it can be human trafficking, anything relating to gender-based violence. This is the dedicated email address for gender-based violence referrals. And just to give you an example of the cases that we do support, so when supporting victims of domestic abuse, it might be the case that we will assist them in applying for independent status. It may be the case that we'll assist them with applying for a change of residence as the parent of an Irish citizen, for instance. For victims of human trafficking, we support applications for family reunification, but also for a change of status. And finally, we can support a number of ancillary applications. So primarily, this would be, at least in my personal work, or I mean, in my work at the Immigrant Council of Ireland, but some caseworkers may specialize in different types of applications. But in my case, I support a lot of applications for Irish citizenship. So when someone has experienced domestic abuse and they've come to me for a very specific question, very often it'll be to apply for independent status. So their permission is no longer linked to the person who's abusing them. So a spouse, a partner, for instance. When this issue has been solved, very often the person may want to apply for citizenship once they become eligible for Irish citizenship. So in those instances, I would support applications for naturalization. So before I get into the specific provisions that exist in Ireland to protect victims of domestic abuse, I just want to give you a quick overview of residence permissions in Ireland. I'm sorry, I'm just going to blow my nose. So there are different categories of people in Ireland who do not need to apply for residence permission. So the most obvious category would be Irish citizens. Irish citizenship can be obtained by birth, by descent, or through naturalization. Irish citizens are entitled to live in Ireland. They do not require residence permission. And it would be very similar for British citizens, EU, EEA, and Swiss citizens. So those people do not need to apply for residence permission. They can come and go as they please in Ireland. But there's another category of people that is required to apply for immigration permission when they come to Ireland. And they are referred as non-EEA nationals or third country nationals. So anyone who is not an Irish citizen, a British citizen, an EU, EEA, or Swiss national is considered to be a third country national. And they have to apply for residence permission when they come to Ireland. Before even coming to Ireland, it may be the case that they will have to apply for a visa. And so there's a difference between visa required nationals and non-visa required nationals. So in Latin America, Brazilian citizens, Brazilian nationals are not required to apply for a visa to come to Ireland. And you may be aware that more recently, Bolivian nationals in the past were not required to apply for a visa either. But since September, this requirement has changed, and Bolivian nationals are now required to hold a visa if they want to travel to Ireland. There is, sorry if I just exit my slides for a second, there is a list you can find online.
Do you want to put it
quite easy to find?
Maybe you can put it in the chat if you want, the link.
Yeah, perfect. I can send on the link. Just making sure that this is, yeah. Sorry, no, this is the Embassy of Ireland in Austria. I don't want to send you a list that it's inaccurate because I've seen one earlier that had not been updated to reflect the fact that Bolivian nationals were now required to apply for a visa. But I'll send I'll pop the link into the chat box when we're doing the Q&A, perhaps.
Brilliant.
I think it may be helpful for people to know. Sometimes it's difficult to know So you can just refer to that list and you'll know if you're required to apply for a visa or not, basically. Let's go back. Perfect. So again, don't worry too much about whether or not you're required to apply for a visa, as long as you find yourself in Ireland. Again, if you are a third country national, you are required to apply for residence permission. You are given 3 months from the date of entry to apply for residence permission. And the type of application that you will make depends on a number of things. So typically, there's 2 different ways of applying for immigration permission. There's one way that's very straightforward, where you'll just go to your local immigration office, which is often located at the local Garda station, and you will register a permission. So that's very straightforward. If you meet the conditions of the permission that you are requesting, the permission will be registered right there and then. And a few weeks later, by post, you will get your IRP card. This is, unfortunately, I just realized earlier, this is an old specimen. So this is, it has since been changed. And I mean, the card is still very similar to this one. The colors are a little bit different. But if you do have an IRP card, it may be the case that yours is currently different to the one I have here showing on the screen. So registering your permission is one way to obtain an IRP card, and the other way is to make a written application to the Department of Justice. Again, in some instances, just going to your local immigration office is not sufficient, and you will need to obtain a permission letter from the Department of Justice before you can go to your local immigration office to register an IRP card. When we ask someone what is the basis of their Irish residence permission, what we want to know is why they were granted immigration permission. So for instance, someone can be granted immigration permission because they are an international student, because they are a migrant worker working in Ireland on the basis of an employment permit, but it can also be because they are the dependent family member of someone who is already residing in Ireland on some basis. I've listed here the most frequent stamps that you may come across. Stamp 1, 1A, 1G, 2, 3, 4, and Stamp 4 EU-FAM. So Stamp 4 is for international students, and the ones really that are important when we're talking about domestic violence are dependent types of permissions. So dependent permissions would be Stamp 1G. 1G is granted to the spouse of a critical skills employment permit. Stamp 3 is granted to the spouse of a general employment permit. Stamp 4 is granted to the spouse of an Irish national. And Stamp 4 EU-FAM is granted to the spouse of an EU citizen. So again, when we talk about a dependent type of permission, it's a permission that is granted on the basis of family relationships. So it can be being married to an Irish national or being the de facto partner of an Irish national. The permission as the dependent of that family member will remain valid for as long as the relationship subsists, or until the person is granted Irish citizenship, at which point they no longer require to hold an immigration permission, or until they become eligible for a change of status in residence permission on some other basis. So for instance, it would be very often what happens is that couples may have children, and the children, when the children are born in Ireland, they may in some instances be entitled to Irish citizenship from birth. Not always, but sometimes. And when someone becomes the parent of an Irish citizen, they can apply to change their immigration permission to be dependent or not dependent on their children, but their permission will be linked to their children. So they are granted immigration permission because they are the parent of an Irish national. If that isn't the case, someone is required to continue to be in a subsisting relationship with their partner or their spouse in order that they may continue to reside in Ireland with their valid immigration permission as the dependent of their partner or their spouse. I hope that makes sense, and I hope it's not too convoluted, because immigration law can be a bit complicated. So if you do have any questions or if there's anything that doesn't make sense, I'm happy to clarify anything or to repeat something that I've gone through already. When we're talking about dependent permissions again, so the family member is typically required to support the renewal of the dependent person's permission. So when your permission is about to expire, if your permission is linked to your partner or your spouse, you have to renew it with the support of that family member. And that means sometimes attending with that person at your local immigration office. Sometimes it means obtaining documents from that family member. And this is where it can become complicated when someone experiences domestic violence, because they can be coerced into doing things that they do not want to do. So they ensure that the family member will accept to support the renewal of their permission. If there is a change in circumstances that may affect someone's immigration permission, that person is required to notify the Department of Justice. And in some instances, they may have to apply for a change of status because their permission is considered to no longer be valid. And so this would be the case, for instance, if someone has permission because they're married to an Irish citizen, the relationship breaks down, they're no longer in a subsisting relationship, even if they're still legally married in some instances. The fact that they're not yet divorced is not relevant. As long as the relationship is broken down, the dependent family member is required to write to the Department of Justice to notify the changes in circumstances, so the fact that the relationship is no longer subsisting, and because their current permission as the spouse of an Irish national is no longer valid because they do no longer meet the requirements, which is being in a subsisting relationship with their Irish spouse, they will be required to apply for a change of status. And what's very important in those instances as well is to notify your change of address to your local immigration officer and to the head office in Dublin. The reason why it's so important, I really want to underscore the importance of notifying your change of address, is because very often when two people break up, one of them will more likely move to a different house, they'll have a different address, and if the Department of Justice seeks to write to you, you have to be able to receive that correspondence. You have to ensure that the correspondence is going to be delivered at an address where you live. In some instances, and I mean, it is quite rare, so I don't want to scare anyone, but in some instances, if the Department of Justice is not able to contact you because you have not changed your address, they may assume that you no longer meet the conditions of your permission, and they may decide to revoke your permission. So these are very limited instances. Again, I don't want to worry anyone. If you do have any questions, if you find yourself in a situation where your circumstances have changed, you're not sure what you're supposed to be doing, I would strongly suggest that you contact us or any other migrant rights organization as well. Again, immigration law can be very confusing. So if you're unsure about anything, I think it's always best to check with someone who has experience with those matters. And again, we're always happy to, answer any questions that you have. So if the breakdown of the relationship, or in fact, there doesn't even have to be a breakdown of the relationship. If a person has experienced domestic violence, they can apply for a different type of permission on the basis of a policy document called the Victims of Domestic Violence Immigration Guidelines. I have linked the policy document here. So again, if you want to have a look at the document yourself afterwards, I would strongly encourage you to do so. The guidelines are a discretionary policy that was most recently updated in 2021, and they are available on the Immigration Service Delivery. They are quite difficult to find. So again, I would suggest you go with the link here. I suppose that's something that can be difficult for people who may need to make an application for a change of status under this policy document if they do not know what exactly they are looking for, if they do not know that this is even available to them. It can be actually quite difficult to find this on your own if you're just searching through the Immigration Service Delivery website. So it's not always very handy. What is stated in this document and what is very important to know is that domestic violence should always be reported, and you do not have to remain in an abusive relationship in order to preserve your entitlement to remain in Ireland. So the policy document is aimed at documented or formally documented migrants who have experienced or are experiencing domestic violence perpetrated by the person on whom they depend for residence permission. It allows those people to obtain an autonomous residence permission. And I'm just going to, open up the link. Actually, I think I have it open already. Because I want to show you. Sorry. Perfect. I want to show you sorry, can you see my screen or can you see my slides at the moment?
We see your slides.
Oh, yeah, sorry, I'll share. Perfect. Can you see my screen now?
Now we see the website. Yes, Irish Immigration.
Perfect. That's great. So this is the relevant page of the Department of Justice website. So this is the Immigration Service Delivery. So Immigration Service Delivery is the, I suppose, sub-department of the Department of Justice that is in charge of immigration permissions. If you want to type in, again, I think it's best to search for this from your browser as opposed to search for it here in the little search function on the website, because it is quite difficult to search for information through that website. It's not very user-friendly. But what I wanted to show you here is that, so on this page, you have information about the guidelines for victims of domestic violence. Here, if you click here, the document, so the actual guidelines will open up. But what I think is very important about this page is that it can be translated. So if you go into the top right corner of your screen, you can change the language to Portuguese and you can change the language to Spanish as well. The guidelines themselves have not been translated. They're only available in English. So what I find very useful when I work with women from the Latin American community, I don't speak Spanish nor Portuguese, unfortunately. And while we do have access to interpreters when we meet with people, so whether it's an in-person meeting or whether it's an online meeting, we do have access to interpreters. If I need to email a person that I'm working with, it's going to be in English. So what's very important for them is to be able to go back to a document that is in their own language. So after a first meeting, I will send a follow-up email where I summarize what we've discussed. I send the link to the guidelines for victims of domestic violence. And what I do as well is that I send a link to this page in the target language. So Portuguese or Spanish, depending on the person that I'm working with. And so I'm just going to go back to the slides now. Sorry. Okay. So when someone is seeking to make an application under the immigration guidelines for victims of domestic violence, there's basically two conditions that have to be met. So to be eligible to make that application, it is a requirement that the applicant's permission is linked to the perpetrator of domestic violence. So this means that international students, for instance, are excluded from this policy document. If an international student is in a relationship with someone and that person is abusive, it is not the case that their permission is linked, because an international student will be granted stamp 2 on the basis that they are studying in Ireland, which means that they're not able to avail of the provisions of contained in the immigration guidelines for victims of domestic violence. So that's one limitation. And the second condition that has to be met as well is that the person seeking to make an application must have a valid immigration permission. So this again excludes undocumented migrants. And this is where it can be a little bit tricky sometimes. And again, whenever there's something that's a bit unsure, I would always suggest that you contact us if you have any questions, because when we talk about someone who's undocumented, there are instances in which we would still suggest that they make an application for independent status. And very often this is going to be where they did previously hold immigration permission, but their permission has lapsed. And very often what we realize, or what we notice in our work, is that the reason why a person's permission may lapse when they have experienced domestic abuse is because their partner or their spouse was being abusive and was using this status as their dependent as a way to further abuse the person. So it could be, it's coercive control in relation to someone's immigration permission. It is domestic abuse, and sometimes it can be the case that an abusive partner will say, if you do not do this, or if you do not do that, I will not renew your permission, or I will make sure that you are deported, etc. These might be things that you have come across as well, that you've heard, that other women have said to you. And one thing that I wanted to make very clear as well is that it is obviously very scary for a woman who's not aware of her rights to hear from a partner or a spouse that they can have her deported. It is not the case. So the only person that can grant immigration permission, that can amend someone's permission, or that can revoke someone's permission is the minister or the Department of Justice. So what an abuser can do is write to the minister to say, we're no longer in a subsisting relationship. And if that happens, the Department of Justice will write to the other person in the relationship to seek confirmation. They will try to engage with you to see if it is the case that you're no longer in a relationship with the person on whom you depend for your permission. If there is domestic abuse in that relationship, and if the person wants to write back to the minister and explain, it is correct, I am no longer in a subsisting relationship with my spouse or my partner. However, please note that the reason why our relationship has broken down is because my husband or my partner perpetrated domestic violence against me. The Department of Justice is, I would say, they're much better at dealing with disclosures of domestic violence, so they will take that very seriously. And I would anticipate, and I would be hopeful that the person who's disclosing having experienced domestic abuse to the Department of Justice would be treated in a way that's very fair, in a way that's very understanding. So I suppose what I'm trying to say is that you really shouldn't be afraid, and you shouldn't be in a position where you stay with someone because you fear for your immigration permission in Ireland. There are applications that can be made, and this application for independent status, if it is accepted, you will be granted an independent stamp 4 permission, typically for 12 months. It is your permission, it is your own permission, it is not dependent on anyone else. You do not need your partner or your spouse to accompany you at your local immigration office to register the permission. You do not need them to renew the permission anymore. And time spent on your independent stamp 4 counts towards applying for citizenship as well. I know sometimes people aren't so sure and they ask me, does it mean that I'm losing the benefits of all the years that I have spent in Ireland? No. You know, if you have spent time in Ireland on stamp 3 or stamp 4 prior to changing your status and becoming independent for the purpose of your immigration permission, it still counts towards applying for citizenship. If applying for citizenship is something that you want to do in the future, stamp 0 and stamp 2 will not count, but every other stamp will count, even if it was a stamp that you had with your partner or your spouse and you no longer have that permission, you have a different permission now. And sorry, just to get back to the actual application and how to go about making that application. It is an application that has to be made in writing to the Department of Justice, so it has to be sent to Unit C of the Immigration Service Delivery. It can be made by the individual themselves. It can be made by a solicitor, but it can also be made by a support organization. And one thing to note is that it remains a discretionary application, which means that it can be refused. If it is refused, you will be given the grounds as to why the application was refused. It is quite rare. I'm just trying to think, in the past year, the applications that I've supported have all been accepted. And since working at the Immigrant Council about 2 years ago, I think we've only had one application that was refused, but the person was then able to apply for immigration permission on a different basis. So it's usually, as long as you have, as long as you meet the conditions, as long as you provide the required documents, it's an application that's often successful. And again, when I say successful, I don't want people to assume that they're going to make the application and immediately it's going to be accepted. I think, again, it's always best to check in with someone who has experience in this field. So again, if you have any questions, if you know someone who wants to make that application, please do reach out to us. And I can never tell people that, the application is 100% going to be accepted, because that wouldn't be fair. Again, it is a discretionary application, so I can never guarantee that it's going to be positive. But in some instances, I can say, I'm looking at, you meet the conditions, you have the required documents, I am quite hopeful that your application would be accepted. Sorry. And so just, with regards to the evidence that is required to support an application, this is the list that is contained in the immigration guidelines for victims of domestic violence. So this is word for word. I've just copied and pasted what's in the guidelines. So the documents that you can provide with your application would be a protection order, a safety order, or a barring order. It can also be a medical report indicating injuries consistent with domestic violence. It can be a Garda report. It can be a letter from a state body, such as the HAC. indicating that it is dealing with your case as an issue of domestic violence. It can be a letter of support from a domestic violence support organization. And it can also be any other evidence indicating that you are the victim of domestic violence. So just a few things that I wanted to note in relation to this list. It is not the case that you have to provide all of those documents. In fact, just one of those documents is sufficient for an application to be accepted. So if you look at this list, you don't have to worry and think, oh, I don't have a protection order, I don't have a Garda report, I don't have a medical report, I only have a letter of support from a domestic violence organization. It can be a refuge, you spent some time at a refuge and they have provided you with a letter confirming that you did. This is very often sufficient to make that application. In relation to the Garda report, even if you do make a report to the Gardaí, they will not give you a report in the form of a hard copy document. What the Gardaí do is that they will give you what is called a pulse number, and the pulse number is just the reference number that is associated to the report that you've made. So if you include that pulse number to your application, the Department of Justice is then able to check on their database and to confirm that you did indeed make a report against that person due to an incident of domestic violence. And finally, with regards to the medical reports, a medical report is not a document that I would suggest to submit unless you do not have any other document evidencing the fact that you have experienced domestic abuse. So similarly, photographs of injuries as well. I wouldn't recommend that they are submitted. The reason being that it can be quite traumatizing for someone who has experienced domestic abuse to provide personal photographs of injuries they have, or to provide a medical report outlining the injuries sustained. And I think these are very private, so it may not be something that you want to share with the Department of Justice as well. Again, if it is the case that there's no other document, that the only evidence available is a medical report, then of course you can submit it. But if there are other documents available, such as a protection order or a support letter from a domestic violence organization, I would consider submitting those first and perhaps not submitting a medical report. And just to note, I suppose, that there are barriers to this type of application. It is not the case that it will solve everyone's problems. Again, undocumented people are excluded from the guidelines. And with regards to the undocumented people, it can be, again, a bit tricky. And this is where I think it's very important to have access to an organization, a migrant rights organization, who may be able to provide you with information regarding your rights and entitlements in Ireland, but information that is based on your situation. Different people have different sets of circumstances, so it's very difficult to say, especially where someone is undocumented. It's very difficult to provide, I suppose, a general answer to say that they can or they can't be regularized because they have experienced domestic abuse. Again, this will be very much dependent on a person's situation. So I would encourage that you reach out to us. Something to note as well that's very important is that, unfortunately, the guidelines are outdated. They're not reflective of the current practices. So if you look at the document for yourself after this webinar, you will see, for instance, that the address that is provided, so the address where a person can send their application, the address is not in fact the current address. It has changed. It used to be the case that this application was to be made to Unit 2. Unit 2 has been renamed a few months ago, and the application has to be submitted to Unit C. So again, if someone were to make that application on their own without any support from anyone, just on the basis of what is written in the guidelines, they may not be in a position to make an application in light of the current practices, I suppose. A big difference as well that is not reflected in the guidelines is that anyone who makes an application that is accepted will be granted STEM 4. I've never seen anyone being granted with any other type of permission than a STEM 4. Obviously, STEM 4 grants access to the labor market, and it would only make sense that someone who has experienced domestic abuse needs to be able to access the labor market to regain their independence and their financial independence. But if you read the guidelines, it is stated that the type of permission that will be granted will be on the same level than the permission that was previously held as a dependent. So basically it means that if someone had STEM 3, they make this application, they should be granted STEM 3, which makes absolutely no sense because STEM 3 holders cannot access the labor market. Again, it's the practice is very different. And if someone makes an application under the policy document, I do not expect that they would be granted any other type of permission than STEM 4. And just to finish up on the domestic violence guidelines, what can be very difficult as well for migrants when they have a permission that is dependent on someone, and even more so if that permission has lapsed and they're now considered to be undocumented. So what is difficult is to access state services such as refuges, social welfare, and healthcare as well. The level of access that can be granted very often depends on someone's permission, on their immigration status. So again, if someone is dependent on someone else for the purpose of their immigration permission, they may be excluded from a number of social welfare payments. And if someone's permission has lapsed or if they are undocumented, they may in some instances be refused access to, social welfare. They will be refused access to social welfare. They may be refused access to some refuges. It is not, in fact, legal. Undocumented migrants should be granted access to a refuge if they need to. But in my experience, I've heard from some of my own clients that they had been refused access to refuges because they did not have a valid immigration permission, or because they had STEM 3, for instance. This is where I suppose it's important to understand the type of support that we as an organization are able to provide. We provide support in relation to immigration law, so it is in fact very limited, and there's quite a lot of things that we're not able to do, which is why we also do a lot of signposting to ensure that our clients and service users are provided with ancillary support, and they have access to legal information and or representation, for instance. So this is going to be, for instance, suggesting that someone contacts Women's Aid if they want to be provided with information regarding court orders. We also suggest that they contact FLAC, so Free Legal Advice Center, and the Legal Aid Board for legal representation as well. It's also important to discuss access to safe and secure accommodation, which is going to be through domestic violence refuges. It can be important to make an application for a barring order in some instances. And I also suggest to contact CrossCare, who are able to provide information about accommodation and social welfare rights as well. In terms of access to financial aid, it can be a good idea to contact your local social welfare office. Although again, if someone's permission has lapsed, they may not be able to make an application for a certain type of social welfare payments. Citizens information centers and family resource centers as well in some instances may also be able to provide information about social welfare rights and entitlements. And finally, I think it's important to mention access to physical and mental health services, which can be accessed through your own general practitioner. And I've also listed My Mind, which is an online counseling website that has, if I'm not mistaken, that has access to counseling sessions in a number of languages. And for a while, they offered free therapy sessions to Ukrainian. I'm not sure if this is still the case, but they did for a while last year, and the sessions were in Ukrainian. I don't want to give you too much information about EU treaty rights residence permissions, because it can be very tricky and a lot more difficult than the immigration guidelines for victims of domestic violence that we've just discussed. But I think it's good to know that it exists and that it is a completely different set of rights and entitlements and applications that will be derived from EU treaty rights, basically. So someone will be granted permission under Directive 2004/38/EC on the rights of citizens of the Union and their family members to move and reside freely within the territory of the member states when they are the family member of an EU citizen. There's two categories of family members: qualifying family members on the one hand, and permitted family members on the other hand. The main difference, and what's important when we're talking about domestic abuse, is that a spouse, so the spouse of an EU citizen, is considered to be a qualifying family member, whereas the de facto partner of an EU citizen will be considered to be a permitted family member. When, I suppose, where that difference starts is that when someone is seeking to make an application for residence permission as the family member of a EU citizen, a qualifying family member will be granted temporary permission while the application is pending, but the permitted family member will not be granted temporary permission while the application is pending. So this is the first very practical difference that you may come across. In some instances where the relationship to the EU family members has ended, the non-EU family member can apply for the retention of their right of residence. And especially where they have experienced domestic abuse, there are specific provisions in the directive that I mentioned earlier. So it is quite a long name. Very often we just call it the Free Movement Directive. So Article 13, of the Free Movement Directive, as well as Regulation 10 of the 2015 regulations. So the regulations are basically the Irish instrument that translated this piece of EU legislation into Irish law. So if you look at Article 10 of the Free Movement Directive, or if you look at Article 13 of the Free Movement Directive or Regulation 10 of the 2015 regulations, you will find very specific provisions that provide for the retention of the right of residence by family members in the event of divorce, annulment of marriage, or termination of registered partnership. So I've just included into this slide the two parts of the article that are, I think, the most important when we're talking about domestic violence. And so what Article 13 states is that in the event of a divorce, annulment of marriage, or a termination of the registered partnership, a union citizen's family member who is not a national of a member state will be permitted to apply for retention if, prior to the initiation of the divorce or annulment proceedings, the marriage has lasted at least 3 years, including 1 year in the host member state. So there is a condition that if your relationship to your EU spouse or EU registered partner has ended, you are permitted to apply for retention if your marriage or registered partnership has lasted at least 3 years, including 1 year in the host member state. However, and this is where point C is very important, if the applicant has experienced particularly difficult circumstances, such as having been a victim of domestic violence while the marriage or registered partnership was subsisting, this condition as to the length of the marriage is lifted. So it's no longer relevant whether you have been married to your spouse for a year, 3 years, or a month even. If you have experienced domestic abuse and you're married to an EU citizen or in a registered partnership with an EU citizen, you can apply for retention regardless of the length of your marriage. Okay, so this is very important. And again, EU law can be very tricky. So I would always suggest that if you have any questions, you reach out to us. There's a very important court decision that was made in 2021, if I'm not mistaken, or it could be 2019, actually, I'm sorry. This court decision came from the Court of Justice of the EU, and it was in a case against the Belgian state in which the person who had perpetrated domestic violence against their spouse had also departed the EU state where their spouse were still, or ex-spouse were still residing. In instances of departure, it is very difficult to obtain the retention of one's right of residence. What was stated in this court decision is that if departure has occurred, retention can still be granted if divorce is initiated within a reasonable period following the departure. And again, of course, the applicant in this case had experienced domestic abuse. So when someone finds themselves in a situation where they have experienced domestic abuse, their EU partner, or sorry, their EU spouse has departed, let's say Ireland in our case, and divorce proceedings were initiated after departure. If those 3 conditions are met, the third country national may be able to apply for retention. But it's still not that straightforward again. So I don't want you to be relying on, I suppose I don't want you to be relying on this slide. Again, please do reach out to us and I'd be happy to provide information that is, I suppose, bespoke to someone's situation. And something that's very important to note as well is that if someone were trying to apply for retention on their own without having obtained information about their rights in Ireland or legal advice from a solicitor, it may be very difficult for them to maintain their rights under EU treaty rights because there is in Ireland one form that has to be completed for someone who wants to apply for retention. It is form EUTR5, and unfortunately it has not been updated to include this court decision that I've just mentioned, and it has not been updated, or at least not in a way that's very straightforward and clear, to include the very specific provisions that I mentioned in the previous slides for people that have experienced domestic abuse. So it can be very difficult. Again, EU law can be very tricky. The main difficulty is that there is a statutory requirement to notify the changes in circumstances within 7 days. 7 days is a very short period of time, and in my experience, the Department of Justice has applied this time frame sometimes very strictly, sometimes less so. So it's very difficult to say, you know, even for someone who may have experience in this field, it can be sometimes difficult to say that in this instance, you know, if you haven't notified the department within 7 days, you'll be fine, or you won't. An added difficulty is that, so when I was talking about retention, I was only talking about retention for registered partners and spouses. So if you are a de facto partner, you are not entitled to apply for retention. What you can do, however, is make an application for independent status under the immigration guidelines for victims of domestic violence. Again, that information is not readily available online, so it can be very difficult if you find yourself in this situation, if you're a de facto partner, to know, what application is available to you. And finally, because this is all very confusing and there's little information available on the Immigration Service Delivery website, there is a risk that when a Stamp 4 EU FAM holder tries to deal with the situation on their own, they may lose their EU treaty rights, residence rights. And the reason why I'm saying this is that there are instances in which it might not be necessary to apply for retention. Again, I don't want to confuse you too much, but retention applies to registered partners and spouses, and it applies where there has been death, departure, or divorce. And where there's domestic violence, it applies if there's also divorce, and in limited circumstances where there's departure and divorce. If the couple remains legally married, there's in fact no need to apply for retention. So if someone has experienced domestic abuse, they have, they're no longer in a subsisting relationship with their spouse, but they're in fact remaining married, they do not need to apply for retention. Very often what we do, and in my work what I do, is that I support people in writing to the Department of Justice, more specifically to the EU Treaty Rights Unit, to notify their changes in circumstances, again, because it is a requirement. And we explain that the relationship has broken down on grounds of domestic violence. However, the couple remain married. They have not initiated divorce proceedings, and under EU law, they are permitted to continue to remain in Ireland with their Stamp 4 EU FAM permission for as long as the marriage is valid. So that's something to keep in mind, because again, because EU law is a bit obscure, some people may not know that as long as they remain married, they can in fact continue to reside in Ireland. And sorry, again, this is very specifically for the family member of an EU citizen. This does not work for the spouse of an Irish national. If you are the spouse of an Irish national and the relationship has broken down, it doesn't matter whether you're still legally married or not. You have to notify the Department of Justice and you have to apply for a different form of permission. Okay, and so I've actually just got to the end of my presentation. So if you want to just write down, our contact details. This is the helpline 01674 0200. info@Immigrant Council is linked to our helpline. However, due to limited capacity, we're not able to respond to email queries. So if you do have general queries, I would suggest to contact the helpline. If you have queries more specifically related to domestic abuse, please contact me directly. So this is my email address, and support@immigrantcouncil.ie is also my second direct email address. This one is, I suppose, more so it was set up as part of a project. But if you do write to support@immigrantcouncil.ie, you will be writing to me directly. And thank you. I'll stop sharing my screen. And if you have any questions, sorry. Perfect. Yeah. If you have any questions, I'm more than happy to answer them.
Thank you very much, Ioanna, for that great presentation, very detailed. So I will stop recording now, and whoever has questions, please feel free to put in the chat or just ask. So I'll stop now. Thank you.